the Allahabad High Court has ruled that civil suit filed by Hindu worshippers and deity in the seeking of restoration of temple at the mosque premise are not barred by the Place of Worship Act. I am talking about the Gyan Vapi mosque here. The crucial decision has come in from Allahabad High Court at the moment. The Masjid committees, remember, the challenge that they have posed now stands rejected. The court further stated that the Gyan Vapi compound can either have a Muslim character or a Hindu character, and that cannot be decided at this stage of framing the issue. The High Court said, and I quote, "The suit affects two major communities of the country. We direct trial court to expeditiously decide the suit in next 6 months' time." That, of course, is the crucial story. At the top of the broadcast with me are my senior colleagues sitting here in the studio, Ashok Bagaria as well as Vijesh Pandey. Ashok, let me come to you first. Let's understand the legality of the matter. We now know that there is a status quo as far as Muslim petitioners is concerned. The court has now decided that the survey will continue from here on. What does it mean for the Gyan Vapi mosque?
Well, first things first, that this matter has been pending in the courts, various courts, for the last 32 years, and there was no clarity on the issue whether the suit can be heard by the trial court or not, because there was an argument which was put forward by the Muslim sides saying that there is a Places of Worship Act which was enacted in 1991 by the P.V. Narasimha Rao government, which said that any religious structure, whatever shape or whatever character it had on 15th August 1947 cannot be altered or looked into by the courts. Now, this was the best argument which was put forward by the Muslim sides, saying that this suit which has been filed by the Hindu sides seeking to reclaim the whole Gyan Vapi mosque premises as their own cannot be heard, and it should be dismissed at the threshold, at the preliminary stage. Now, after 1991, the matter went to the district court. In 1998, the district judge Varanasi said that this issue can be decided, but it cannot be decided without taking evidence first. Thereafter, after 1998, the matter went to the Allahabad High Court. In 1998, the same year, the Allahabad High Court said there shall continue to be a stay on all the proceedings in the lower court. Now, from 1998 till today, there were numerous hearings, and there was no clarity as to when will this matter be decided. Now, one very interesting thing I would like to point out here was something which happened in the month of August. This case was for the last 2 years, between 21 and 22, was heard by one particular judge, Justice Prakash Padia, and he had heard both the parties and reserved the verdict in the case. But almost just before Justice Padia was to deliver his verdict, the Chief Justice of the Allahabad High Court changed the bench and transferred the matter to Justice Agarwal, who delivered the verdict today. This was questioned by the Muslim sides in the Supreme Court, saying that this kind of an action, unilateral action by the Chief Justice of the Allahabad High Court to transfer the case from one judge to another is unwarranted and is bad.
Does it happen frequently?
It doesn't happen frequently, and that was the reason why it came to the Supreme Court. And the Chief Justice of India, when he looked into the matter, he came to a conclusion that what I see is that there were cogent reasons before the Chief Justice of the Allahabad High Court to transfer the case, and we are not going to interfere with it. Today, Justice Agarwal has delivered his verdict, and 3 important things he says in his verdict. Number 1, that the Places of Worship Act is not a bar. This is a very important finding. It cannot act as a bar on deciding the suit. Number 2, that this matter has festered on for so long, 32 years. It has to be decided quickly because it concerns 2 communities. And he says that within 6 months, the trial court should decide the suit. Number 3, he says that this matter cannot be decided without taking in evidence. The trial court is free to decide if they want the assistance of the Archaeological Survey of India to gather evidence. And he further goes on to say that if Archaeological Survey of India has conducted a survey in some another matter, that can also be considered to decide this particular issue. So today, the most important, as I said, the biggest stumbling block, which was the Places of Worship Act, has been demolished by the Allahabad High Court. It is saying that it cannot act as a bar in deciding this suit. But at the same time, one quick word I also want to add is that the same issue, the constitutionality, the legality of the Places of Worship Act is pending in the Supreme Court. And the whole question whether the Places of Worship Act can allow any legal litigation or any litigation to change the character of a religious place, can it be done or not? Both these questions are pending before the Supreme Court. So, in this particular case, the Supreme Court of India will have the final word.
Okay, Supreme Court will have the final word. And before I go to our guest, Brijesh, just to low down on what does today mean for people, for Muslim petitioners. We know that they have lost the case as far as maintainability is concerned. But what does it mean for people who are looking at what's going to happen in Gyan Vapi next?
Well, I think, it's a big setback for the Muslim side because the Allahabad High Court, as Ashok, laid out in threadbare about, how the entire arguments was demolished. The case which he mentioned about the transfer judge did raise further question, and the CGI said that they had cogent reasons. But as, people have read, nobody knows the cogent or the coherent reasons which were put forward and, what led to the Chief Justice of India decide that. But so be it. I think, this issue is something which is, as said by the court, that there are two large sections, the Hindu side and the Muslim side are looking into it. I think the court should also, the Supreme Court should also exercise the same kind of exigency and settle the matter once for all, that whether it covers under the Religious Worship Act or not. Because if it doesn't, then there should be, as Mr. Jain, who is one of the the guest here in the show, yesterday said that this is not the end of it. There are 21 more cases which he wants to file, and in 21 different parts of the country where temples were destroyed to build other religious structures.
Absolutely.
So it is, I mean, he objects to the use of word Pandora box, but I think I can use it that, it will lead to opening up of Pandora box as to, where do you stop and where do you start? One line before you can go to both Mr. Jain and the other guest is that at the start when this entire Gyan Vapi mosque thing started happening, RSS Sarsang Chalak said that we should stop looking for a mandir under every masjid, and this led to such a vociferous and ballistic attack on Sarsang Chalak, which I haven't seen till date.
Okay, so political ramifications as well as the ramifications for the people who are following up on how many mandirs are there below every masjid. Anil K. Verma, political analyst, also with us on the show. Anil, good to have you. What are you making of today's order? It paves way for at least some finality on Gyan Vapi Mosque.
Obviously, the court is, has taken a very interesting decision. And the first interesting part of the decision is that the entire business was centering around the Worship Act 1991. And there were at least three routes to that, repealing the act by Parliament, rescinding the act by the Supreme Court, and of course, any other route that might be contemplated by some people. But today, what they have done is a very interesting judgment that now this Religious Worship Act has to freeze for the time being, and the court will probably decide, the trial court, that was the character of the Gyan Vapi Mosque prior to 1947. So we'll have to wait for that for the next 6 months. That is one. The second thing is that, a historical wrong is, it appears that a historical wrong will be done. Post-independence, Shweta, do you remember any mosque having been built so close to a temple? At least in my 70 years of life, I have not seen any mosque intruding into a temple or being built so closely, So these things, they are very hard facts that how can a mosque and the temple, coexist? And the court has taken a very loud decision on this, that it can either be a mandir or a masjid, and it cannot be, an intermingling of both masjid and masjid. So this is a very clear pointer to the shape of things to come. And the third very interesting part is that the court has given a free hand to the trial court that they should bank on the ASI, or they can take the help of ASI. And given by the fact that the ASI has lot of evidences, in case of Ram Mandir, to which also the court can take advantage of, and also fresh digging and by the ASI as per the core directive. I think some very interesting evidences, historical evidences can be presented by the ASI to the court, on the basis of which the court will have a very, very convenient, it will be very convenient for the court to take a call on all this. So to sum up all these things, I think the Hindus who have been struggling for extrication of their temples from the historical wrongs, they have an optimistic position right now. Shweta?
All right, Abhishek Atre, Advocate, Supreme Court, also with us on the show. Abhishek, you heard our previous guest. Where does the buck stop? I think the question here is, it is not just Gyan Vapi where you can find remnants of a temple. There will be various such temples, various such mosques built on top of one another. What does the Places of Worship Act tell you? And, keeping in line with what the court has said today, where does the Places of Worship Act stand? Is it challenged? Is there a need for a change in the law? What does the law say?
The Places of Worship Act came into existence in 1991. Since then, it was thought that except Ram Janmabhoomi dispute, it bars all kinds of suits in relation to all kind of religious characters in entire India. Because the wordings are of Section 4 of that act. Should I read the exact wording?
Sure.
This is, it is hereby declared that religious character of a place of worship existing on 50th August 1947 shall continue to be the same as it existed on that day. Meaning thereby that whatever was the religious character on the day of independence, it should not be changed. But here in this matter, what was decided today, that what was the religious character? It is a question of dispute. It's a question of fact. What was the religious character of a particular religious structure? It was to be decided by the trial only, and not on the basis of pleadings of the parties, not at the time of framing of issues. And on this ground itself, in 98, these suits were stayed. Since 98, now 32 years have passed. This issue was still there. There were so many litigations. After all, lastly, this judgment came, which we all welcome, that the religious character has to be decided. What was the religious character? Whether it was a temple, it was a mosque, it was to be decided on the basis of evidence only. And now ASI report has also come, no doubt in sealed cover. But whatever is the religious character, it will be decided on the basis of ASI report. So the interpretation was rightly done by the High Court, that what is religious character, it's a question of fact, it will be decided only after trial.